This
Thank
Honorable
you.
Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Court of Appeals. We appreciate you agreeing to participate in these oral arguments via Zoom. If we encounter any technological problems throughout this argument, just bear with us. We'll get it figured out. We've unfortunately have done that before, but it's always worked itself out, and I promise that no one's rights will suffer as a result of any of that. Both of you are experienced practitioners, and as we have this hearing today, I want to remind each of you that we will be conducting ourselves as if we were all in the courtroom together. The same formalities, the same rules, the same procedures will apply, which essentially means each side gets 15 minutes to make its oral argument. And if you're the appellant and have reserved rebuttal time with Mr. Hibner prior to the beginning of the argument, you'll receive that rebuttal time as well. Before we get into the arguments today, I want to take a moment and introduce your panel. It is Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before you call the case?
No, Your Honor.
All right, you may call the case then.
Jennifer Pallotta Gaby versus Tony Harold Gaby.
And we will hear from the appellant.
Thank you, Your Honor. And may it please the court, I am Crystal Jesse. I'm requesting reserve 5 minutes for rebuttal time.
Yes, ma'am.
Thank you. Today I'm before the court and I represent Mr. Tony Gaby. He is the appellant. I will refer to him as the father in this matter. I do apologize. I appear a little bit darker on screen today than previously. Let me know if you have any issues seeing me or hearing me. We are before the court on a petition to modify filed by the father in regard to 2 children, Piper being the oldest and Alyssa the youngest. I've presented 3 main issues on appeal. The first 2 go hand in hand, and I will take them up together to begin with. As you can tell from the record, the original parenting plan was entered into in 2017 after a trial on the merits. As you can tell from the final judgment, the court noted that there was a temporary parenting plan in place prior to the trial and actually thanked both of the parents, though both of them expressed concerns at the final trial. The father had substantial time, not equal, but substantial. He had concerns about the mother and vice versa, but neither of them had motioned at that time to go back before the court before the parenting plan was entered. At the trial, the court ended up entering a parenting plan, giving the father only 55 days at that time. Armbruster had not went up to the Supreme Court. Our firm had not argued that yet. The court specifically indicated at that point in time that this was largely due to the father's work schedule. Also, the court indicated that perhaps the father could do some things, the 2 children did testify, to rekindle his relationship with the children. The court was very specific, said, I suggest you do additional parenting classes, perhaps anger management classes, because they think you have a loud voice or they perceive it as loud. And maybe you should go to therapy to try and reunite with the children. The father's done all that. And as is found by the trial court, that was what was the material change. The father has gotten better. And as the father's relationship has gotten better, the court found that the mother has pulled back. She has done nothing to reinforce the father's relationship when she had the opportunity. What I would submit to the court is you have 2 very different children here. And we have 2 very different timelines as to the children. When you look at Piper, the oldest, from the parenting plan 2017 forward until we filed until 2018, they went to therapy, all 3 of them. They did very well. Piper was reluctant and always has been, but as the therapist testified, she progressed. She was doing well. She was enjoying visits with the father. Alyssa has always done well. She was younger during the divorce. She's more of the country girl, likes to go fishing with her father. And so she had progressed. At some point in time during therapy, the father goes to the therapist and asks her how to introduce his new girlfriend with whom he lives. The therapist then lays out a plan in a therapeutic setting, notifies the girls, and everything seems to go well. During the process, the mother was asked by the father, at the recommendation of the therapist, Will you join me in therapy? She admits on the record that she has, as she stated, she denied going and said she has no parenting issues, so she does not need to go to therapy. It's notable, though, that when the mother finds out that the children were introduced to the father's new girlfriend, she gets angry. She calls the therapist and has concerns that she said was told to her by the children. They're unfounded concerns. As the therapist testified, she broached the issue with both of the children, and they were completely unfounded. Mother still did nothing to try to support the father's relationship. However, this is the first instance in which the mother took steps to thwart his relationship, specifically with Alyssa. Alyssa became closer with not only the father, but his girlfriend. Alyssa would Snapchat the girlfriend, would text the girlfriend. The mother made her delete the girlfriend from Snapchat, made her delete her phone number so she could not text her. As Alyssa testified, she was so embarrassed about it, she didn't want the girlfriend to be upset, so she deleted the whole Snapchat app so no one's feelings would get hurt. The mother had an opportunity there to help the father with his relationship with the children, and instead took it a step further. Now, we filed this August 30th, 2018. Someone told the children we filed. At the point of filing, at that time, Piper took a step back and become more introverted again. The father did not pressure that. There were times he did not pressure her to come to visits because he had seen that before. Alyssa continued to fare very well. We take the depositions almost a year later, and when asked, neither child had a real reason for not wanting to come see father. However, that changed when we went to court. Piper specifically said she did not want to come see the father because she believed that the girlfriend and he had an affair prior to the divorce. This was the first time anyone had ever heard that, the first time it had ever been brought up. Alyssa simply said that she felt pulled in between the mother, the father, and her sister. She didn't have a reason. Alyssa has always done very well with the father. What's notable to mention is that also during the pleadings, if you notice, the mother filed a motion to stay the father's visits with Piper. The court, sui sponte, dismissed that because the mother made no allegations of harm or possible irreparable harm. In our opinion, it's just another instance the mother took to try and alienate the father. Now, it is clear from the record that she took steps with Alyssa to try and alienate her once she got upset that Alyssa was doing well. She did nothing, as the court found, to reinforce the relationship with either girls. However, the court did find there was a material change in circumstances and gave the father extra days, only gave the father 90 days. The court did not go through the factors as set out in 36-6-106, and specifically as set out in Armbruster, the court did not maximize the time with the children. We even ask in court, why can we not have time when the father is off work and the mother is working? Rather than place the children with a third-party caregiver, why can't the father have that time with the child? During the school year, the court would not give us a reason why, but declined to answer that question. I specifically, in my brief, went through all the factors set out in 36-6-106 to show that, yes, there has been a material change. The 4 things that the court pointed to that the father has completed are good, including the therapy. But if we weigh in all the other factors, he should have substantially more time. I also cited to several cases, 2 of which I would like to bring to the court's attention. In Ray Lennon R., the case that I believe is directly on point, the Court of Appeals reversed and held that the permanent parenting plan did not allow the mother to enjoy maximum participation with the child because of her work schedule, though there was nothing in the record to support that. I would submit that that's the same in this case. We say his work schedule is from 1 a.m. to 1 p.m., but like in Ray Lennon, in which the mother in that case lived with her sister that helped while she worked unconventional hours, the father works unconventional hours here. As he testified to, he lives with his girlfriend, who has been a longtime partner. He also lives 5 feet from his parents across the road. He's lived in the house the majority of the children's lives. Therefore, we submit they can help as they helped and always help both of the parents. So we should not hold it against him because he has unconventional hours. As I'm running out of time, I would simply address the last issue I raised in regard to the parenting time. Very simply, the court gave us equal parenting time in the summer, though in the proposal by opposing counsel, it shows that the mother would have 2 weeks back to back. Therefore, we did not get the full summer as the court granted, and we also did not get the day count as the court granted. We would submit the day count would be between 104 and 108 days, simply because if we take out the 2-week period and divide it, then we fluctuate 7 days there. So at least the summer needs to be specifically addressed. And the father deserves the day count for the extra days and the extra week that he was not given. We did not have a hearing on that. The court just asked us to simply submit separate calendars. And as a school calendar fluctuates every year, it can be anywhere between 8 weeks in a summer to 10 weeks in the summer. Why opposing counsel put 2 weeks back to back is what's confusing, because the order was very clear that my client's time was maximized in the summer by a simple split of the summer equally between the parents. Also, Your Honor, I was simply asking Nauvoo versus Nauvoo, the court finds that the General Assembly recognized the importance of the relationship of both parents. That's what we're seeking here today. He cannot have a relationship during the school year with the children if he's not allowed to visit with the children. We have substantial time. We can pick up the children every day from school. We can keep them regularly during the school year. We've been there, we've been part of their lives, and we just want to continue that. Thank you. I will address any questions you may have.
Seeing none, we will hear from the appellate. You need to unmute, Mr. McAfee.
I was waiting for the timer to start before I addressed the court. Good afternoon.
Go
May it
ahead.
please the court. This is Joseph McAfee. Of course, I represent Miss Gaby, Jennifer Gaby. And in my mind, when I was reciting, sort of outlining what I was going to argue here, I decided I probably shouldn't change how I'm going to refer to everybody. So I'll probably say Miss Gaby and Mr. Gaby. And I hope that doesn't cause any confusion there. But to start out in rebuttal, I suppose, since this is my opportunity to speak to the court and want to make sure I take full advantage, I would implore the court to look through the record and the transcripts and examine what the true facts are. And I know that it's difficult when you're not observing the people testify, like the trial court, which is in the best position to assess the credibility of witnesses and determine whether they can be believed for truthfulness or accuracy or any other reason to perhaps be a little skeptical of someone's testimony. But in our brief, of course, we responded to the 3 issues that Ms. Jessie raised in her appeal, and specifically addressing some of the issues with the relationship with Mr. Gaby and Piper and Alyssa. There's plenty of testimony in the court here in the record about the status of the relationship with the children of Mr. Gaby whenever we had this hearing on December 2nd, 2019, as compared to when he filed his petition August 30th, 2018. This is a year and a few months later. Well, at the time of filing the petition, the children and Mr. Gaby were engaging in therapy with Miss Carrie Eastep, the therapist that Miss Jessie mentioned. Well, she had a child herself in early November, and that therapy and visitation ceased at that time. And that was also around the time that Mr. Gaby introduced the children to his girlfriend, Michelle Troush. And we would suggest that a year and several months later that unfortunately that therapy had ceased, and Mr. Gaby did not take the initiative and reinstitute therapy with another person. And just want to make the court aware that there are other factors at play here other than the suggested implication that Miss Jennifer Gaby, Miss Gaby, is somehow poisoning the well between Mr. Gaby and the children. It's our suggestion and position that, of course, Mr. Gaby has poisoned the well with his children himself. The testimony of Miss Gaby is clear that she has not spoken disparagingly about Mr. Gaby nor has she discouraged the children from having a relationship. These are mature, exceptional young ladies. At the time that this case was heard in 2019, one was a freshman in high school and one was a seventh grader. These are children that participate in social events and the arts, such as choir, team sports. They make A's and B's in school. Piper, the eldest, is taking advanced placement courses and makes perfect grades. So these are mature young ladies that I think that certainly the record would suggest that their testimony should be afforded a great deal of credibility. Now, in terms of analyzing what the court found, it seems that based on the court's ruling back in 2019, that true, he did not address each specific factor like the court did back in 2017. However, he did make sure to mention that his findings were that all factors remain the same except for the factor which considers whether or not each parent is encouraging of a relationship with the other parent. I don't want to even try to quote that factor.
Let me
And
ask you,
also,
Mr. McAfee,
yes, sir.
is the order from 2017 a part of the record in this case?
Yes, sir. I think it's in volume 1, if I'm not mistaken.
Volume 1?
Yes, sir. I believe so.
Okay.
And I promise I don't have the entire record memorized. It's just for some reason I feel like I can recall that.
Let me
as far
ask
as the other,
Let me ask
Yes,
you
sir.
a follow-up question, Mr. McAfee, and that is the court's finding regarding the previous order in dispute? In other words, the trial court said, I think all these factors are the same except for some specific factor. Is that disputed between mother and father?
Okay, I just want to make sure I understand the court's question here. Are
Yeah.
you asking whether or not we dispute the court's finding in terms of whether our client is any longer encouraging the relationship between Mr. Gaby and the children?
I think I have a more general question, and that is this. The trial court said that everything is the same except for a specific factor. Is there a dispute in this appeal by the parties that is an accurate finding?
I'm not sure what Ms. Jessie's position is, but in looking at the court's ruling from back then, all those factors, just to get to the answer of your question, Your Honor, they are found by the court either to not apply to these specific parties, or they either slightly favor the mother or greatly favor the mother. So we're certainly not disputing that finding in terms of whether those factors would still apply the same way back in 2019 as they did in 2017, especially the ones that specifically favored Miss Gaby.
Okay, thank you.
And in terms of the other factor that the court found in favor of Mr. Gaby, the court found that Mr. Gaby's work schedule had improved, and now that factor would favor him enjoying more parenting time with the children. It is true that his schedule has changed significantly. Now, Mr. Gaby, who is I think he's a truck driver, drives the big trucks for Greenville Oil. Well, he goes into work at 1 a.m. and he gets off work, according to his testimony, at 1 p.m. in the afternoon. That's Monday through Friday. And what to point out about that is he now would be able to participate more in sporting events and extracurricular activities after the children get out of school during the school year, of course. And he's done that. We don't dispute that he's coming to ball games, and he's coming to pageants, and he's coming to choir events and Veterans Day presentations. But even though that may allow him to attend more of the fun events and photo opportunities, that's true. And it's certainly not a negative thing that he's attending these things, certainly not. But if he goes into work at 1 a.m, his children are going to be without him, even though his girlfriend admittedly would be there at the house from 1 a.m. overnight until they get up and are completely responsible themselves for getting ready to school and then traveling and getting to school. So with all due respect to the court's finding, we would actually have to disagree that schedule has improved in terms of his parenting, to the extent that he would no longer be able to be at home while his children are sleeping on school nights. So
McAfee.
rather, Yes, ma'am.
Mr. Mack, you seem to be alleging that the father's motivations in changing that work schedule may be in question. Did the court make a specific finding as to that?
I think the court found that, well, if I can kind of go back for a second, back to the 2017 order, I respectfully disagree with how the court sort of set up a roadmap for how the court would then later find a material change in circumstances. He suggested, hey, change your work schedule, you'll get some more time. That's a generalization. And then he did change his work schedule. He did. And I think that the father's motivations were to get more time with the children and changing that work schedule. If that is if that's your question, Your Honor, I just want to make sure I address your
Well, Mr.
question.
McAfee, you referred to the father doing that to get, I think in your words, photo opportunities. And so
Yes.
I was just asking you, did the court make a finding that the father had some kind of improper motivations in that change of work schedule? Because obviously the court relied upon that change of work schedule as part of reasoning for its order in this case. And you seem to be alleging that father did that with an improper motive. And so that's why I'm asking you, did the trial court make findings as to that?
The trial court did not make a finding as to that. Perhaps my genesis of that thought process was the testimony of Piper. At the time of the trial, Piper, Gaby, the oldest child, testified, and it was her suggestion in her testimony that she understood her father's motivations perhaps to be improper, just so people could see her with him and him coming to events. And that's where I got that idea. But that was not a specific finding of the court. No, ma'am.
Thank you.
In terms of the thwarting of the relationship that the appellant suggests, of course, the record is devoid of Miss Gaby doing any action to thwart the relationship. Now, the court did find, rather than back in 2017, when the court found and encouraged and praised Miss Gaby for not disclosing the affair, not disclosing any of the other issues perhaps faced by the father, and not poisoning the well. But in this particular trial, the court did find that perhaps Miss Gaby is no longer as actively encouraging the relationship between the children and the father. So I certainly do concede that, but there's no evidence in the record we would suggest to the court that Miss Gaby has taken steps to alienate the father. Miss Gaby has apparently, while the children have been in her care and in her care during all previous school nights after the separation occurred, done a fantastic job in helping the children with their educational needs, their social development, their just their training in life seems to be going very well. And she, in terms of what Miss Gaby has done, clearly she's a former educator. That's certainly an advantage to her and certainly not a knock on Mr. Gaby. But one thing that stands out to me is that, and I'm taking a little bit of a risk here because I don't want to get too into the weeds, but Mr. Gaby wants what he wants. Okay, he wants more time with the children, but there's no testimony from him or the children, we would suggest, and that there's no testimony from them in terms of him taking an active role in being responsible for the parenting. Bless his heart, he wants to take the children grocery shopping during his limited parenting time, but if he wanted to take full advantage of his parenting time, he would, of course, know what the children wanted to eat and make sure he was fully stocked in the 12 days between visits, and make sure he was maximizing his time cooking with the children or doing some other event like, I don't know, building Legos or something, even if these older children maybe wouldn't want to do that. But that would certainly be an example of more meaningful taking advantage of his parenting time. So in terms of the third issue, which is the calendar issue, we would suggest that there was certainly dispute among myself and Miss Jessie in terms of the actual number of days that the parenting plan would suggest. The calendar was submitted not by the court or to determine exactly what the schedule was, but to assist the court in determining exactly what number of days would be appropriate based on the court's ruling and the schedule that the court had ruled upon. The 2 weeks that are open, 2 weeks in a row there for Miss Gaby in July was either taken into account some sort of vacation or perhaps just some sort of clerical error on my part in filling out the calendar. But if you look at it, he has a week that follows that. So his weeks and days over that summer are exactly the same. The point of that calendar was to try and calculate for the year 2020, how many days the children would spend with Miss Gaby, how many days the children would spend with Mr. Gaby. We rounded up from the 90 that I calculated in the calendar to 95, not just to be generous, but to take into account the fluctuation in school days and sometimes holidays, and different days can fall on different days. So we wanted to be fair to him, and we rounded up to 95 rather than sticking with the original 90. But just to make sure that I hit one final point, which is the court was very careful and did not make this specific finding. And so I don't suggest that the court made this specific finding, but if you look, the court, it can be understood the court was well aware of how these children are doing. They're doing very well. And he did expand the time with the father. We respectfully disagree that that's what the court should have done, but I'm not going to suggest that the court erred by doing that because of the facts and the way the court analyzed things. No problem there. But he was very careful to tailor a parenting plan that did maximize time with the parents, but consistent with the best interest of the children, made sure that Miss Gaby was in charge and had those children every night before school to make sure that all their academic needs were met and they didn't start having any issues during this very formative and important time in their life. Unless the court has any further questions, that's my argument. Thank you.
Well, let me ask you, Mr. McAfee, the parenting plan that was entered in terms of the days count, what does it provide for? Is it 90, 95, or 104, or does it not have a number at all?
The parenting plan that was entered, and I don't have it right in front of me, I'm going to have to go on memory, Your Honor, so please forgive me if I'm off. 90 days for the father, or 95 days for the father, and I believe that minus 365 for the mother. I don't remember the exact number of days, but he went up from 52 days to that 95 days. May I finish answering your question, Your Honor?
Go ahead.
It went from the 52 days up to 95 days, if I recall, and then the balance with the mother. So he did get, I think, around a 70% increase in his time.
Okay.
All right, thank you. We will hear rebuttal from the appellant.
Yes, thank you, Your Honor. A few things that you all asked a question about. Yes, all 15 factors are disputed. I specifically laid out all 15 factors from page 18 through 28 in my brief. We dispute any factor that the court did not take into consideration. And we also put in how the father has improved, or if he had time during the school year, could improve. Additionally, opposing counsel said that his client did not thwart their relationship. Specifically on page 19 and 20, I cite to this transcript. The mother refused to meet with the counselor, page 75. The mother said she did not want to be involved in counseling, page 83. The father discussed his concerns with the mother to build a stronger relationship, page 42. The mother testified and admitted she did not actively encourage Piper to see the father, page 132. Piper testified that her mother had not encouraged her to go to the father's house, page 227. She refused to allow the father extra parenting time when she herself was not with the children. That's on page 81 through 82. So the mother had opportunities. The father was doing better and the mother pulled back. The other issue is that, quite frankly, the father has done much to increase his time. The only negative finding, when you ask, from the court was as to the mother, that the mother did not encourage a relationship with the father. But we did nothing to correct that. We didn't say, hey, since you did not encourage the relationship, dad's off every day at 1 p.m. And even though we asked, we're not going to allow him to we're not going to allow him to pick the children up for school, though he has the ability to every day to take them to their extracurricular events. The other thing the court did not do, as I said from the beginning, we have 2 separate children. When analyzing the 15 factors, I understand their preference has to be taken into consideration, but they're separate children at separate ages. Alyssa's parenting time should not depend on Piper. I understand that Piper may be of an age to want less time with her father and has other things that she wants to do, but it strikes me as odd that they were doing fine until we filed this petition to ask for more time. Also, we also asked that the court analyze the children differently. Let us have more time with Alyssa, since our bond with her is continuing to grow. Analyze Piper separately, allow them to enjoy time together. But if Alyssa wants more time with her father, she should never feel burdened by that. And that's what the mothers made her feel by having to not talk to the girlfriend and not being allowed to Snapchat the girlfriend. One other thing I'd like to bring up, the parenting plan, when you ask Mr. McAfee, shows 90 days. Even Mr. McAfee admitted it could vary. He thinks 90 to 95 days. I submit if we keep the day count in the order as is, it could vary from 104 to 108 days. In rebuttal, we are simply asking that the trial court remand this matter back to the court with the specific instructions as we did in Ray Lennon and in the Nevaeh versus Nevaeh case. And I hope I pronounced that correctly. Please disregard my East Tennessee accent. But to maximize the father's parenting time, even if that means maximizing Alyssa's independently of Piper, because it is clear from the testimony, Alyssa has no reason that she does not want to go see the father, but for her relationship with Piper. Piper only gave us the reason of when she went to court of the father's relationship with his new girlfriend. So we would submit that the court did not apply Armbruster and did not maximize the parenting time and did not give us a reason why the court was not maximizing the parenting time, other than to say it's been such a long time since you filed the petition. It was barely a year, and that's not a long time in the eyes of the court, especially in COVID. We cannot hold it against the father because it took him a year to get from the day of filing the petition through discovery, through mediation to court. Unless your honors have any other questions.
I see none.
Thank you, your honor. I have nothing further. You all have a great day.
You too. Thank you. We appreciate your argument. We will take this matter under advisement, review the record, and attempt to get you an opinion at the earliest possible time. I want to again thank Mr. Hebner and the AOC staff for all their hard work in making this possible. Mr. Hebner, if you will recess court until the call of the next case, please.
This honorable court is now in recess until 2:30 p.m.
Thank you. Thank you, counsel.